Lending money, whether to a friend, business partner, or real estate investor, carries real financial risk. In this short video, I will walk you through the steps to secure your loan and protect yourself as a lender. As always, these videos are intended only for informational purposes. They are not a substitute for, nor should they be constituted as, real legal advice. You should always seek out your own independent counsel, whether that be the attorneys at Holmquist Gardiner or another firm. Before handing over any money, be sure to conduct a financial review of your borrower. That means looking into your borrower's assets, liabilities, income, any outstanding judgments, or other financial terms that would allow you to assess the creditworthiness and financial strength of your borrower. A background check is equally important. It allows a lender to look for any prior bankruptcies, unpaid judgments, litigation, tax liens, or any other red flags that would disqualify a borrower. This is a lender's first line of protection. If a borrower is judgment-proof, that is legal slang for has no money or assets, then no amount of legal guidance or paperwork will get your loan repaid. Next, always consult with competent legal counsel. A lawyer will help you comply with lending laws, usury limitations, and documentation to secure your loan. A lawyer will ensure that you have your loan properly documented, recorded, and collateralized. The backbone of any loan is the promissory note. This is the borrower's written promise to repay the lender pursuant to the terms therein. It is the document that establishes the debt itself. All other loan documents will go to enforce the terms of the promissory note. To truly secure your loan, especially in real estate-related lending, it is strongly recommended to pair your promissory note with a deed of trust. The deed of trust is the security instrument involving three parties: the borrower as trustor, a third party as the trustee, and the lender as the beneficiary. The trustee's role in the deed of trust is to hold the property in trust for the lender in case any default arises. If the borrower meets their obligations and does not create a default, then the trustee never gets involved. However, if there is a default, then the deed of trust vests the trustee with the authority to conduct what is called a non-judicial foreclosure and sell the property encumbered by the deed of trust at a public sale. The deed of trust is what takes your loan from an unsecured IOU to an enforceable, collateralized investment. Collateral is any property pledged to secure the repayment of a loan, often real estate, but sometimes other things such as inventory, equipment, or membership interests in the company itself. Once pledged, the deed of trust or other security instrument creates a lien. This lien allows the lender to claim interests in the collateral in the case of a default. Collateral is the lender's fallback plan in case negotiations with a defaulting borrower do not pan out. Without collateral, a lender is merely relying on the borrower's promise that they will repay the loan as and when due. Before accepting any collateral, you must evaluate any encumbrances thereon. That is, liens, loans, easements, covenants, or restrictions placed on the property being pledged to you as collateral. Why does this matter? Well, because if you accept collateral that is already encumbered, for example, by a mortgage, then your position as lien holder is subordinate or inferior to the existing encumbrance. For example, if you wanted to lend money to someone for the purchase of a primary residence, but that home already has an existing mortgage, then in the event of a foreclosure on that property, the existing mortgage holder would get paid out first. If there's not enough money left over after the foreclosure sales proceeds are paid out to the first position lien holder, then all of the subordinate lien holders will get nothing. That is why it is of vital importance to understand where you are situated in the priority stack prior to finalizing any loans. If a borrower cannot or will not pay, then a lender's remedy is foreclosure. Under the deed of trust, most foreclosures happen under a non-judicial process. That is because the non-judicial version of this foreclosure process is much faster and less expensive than the judicial version. Foreclosure is never the goal of a lender. However, it is the final enforcement mechanism that makes secured lending viable. To sum up, do your due diligence. Work with counsel. Document your debt through a promissory note. Secure your loan with collateral and a deed of trust or other security instrument. Make sure that you check on encumbrances for your collateral, and understand the foreclosure process. Handled correctly, secured lending minimizes risk and protects your investment. Thanks for watching. Again, this video is for informational purposes only and should not be a substitute for legal advice. If you have any questions, please reach out to your friends here at Holmquist Gardiner.